And now I will just demonstrate that that last statement is not true. Right, good afternoon, friends and colleagues. When Klaus Grabinski put that slide up, and it said 28 EU member states, and then he's changed the number to 27, part of me died again. But, interestingly, the leading case probably, I think most people would agree, on bad faith within the Court of Justice is the case of Sky versus Skykick. And weirdly, that case was argued before the Supreme Court for 2 days in June of this year. And there will be coming, before the end of the year probably, a judgment of the United Kingdom Supreme Court which will help, I hope, to clarify what the EU law is in relation to bad faith filing. Now, I personally think that's ironic and poetic, but isn't it strange? Now, good. Bad faith. This is turning out to be a very elastic concept. There are a growing number of cases which raise the issue, and depending on the way the judges deal with them, they have the capacity to have a destabilizing effect on the structure and system for trademark protection. And I will hope to explain that to you as I go through the notes on my paper. So it's trite to say that we have a first-to-file system. Yes, we do, but let's be clear what that means. What it means is that you do not have to do anything more at the application stage than to fill in a form, comply with the administrative requirements for it, and pay the fee. And if at the end of the exercise you get a registration, you do because it's a first-to-file system which operates on the principle that you have title to a trademark by registration, not registration of title, and that's the point that I make in numbered paragraph 3. Now, the basic proposition, easy to state, but let's see how we develop this. The basic proposition is that the right, and it is a right, the right to apply for registration of a trademark cannot validly be exercised in bad faith. Let's expand that a little bit further. The question is not whether the trademark itself is a good trademark or a bad trademark, or whether it's registrable or not registrable as a trademark. The question is whether the applicant has filed an application for registration which involves improper use of the trademark system for acquiring a mark by registration. Bad faith is an autonomous concept of EU law. Well, of course it is. And that's because the Court of Justice would never, ever allow member states individually with their own separate cultural legal traditions to evolve their own separate concepts of bad faith. It was never going to be otherwise. It was always going to be an autonomous concept of EU law. Now, the most useful document that I found when I argued the Sky case in June of this year, the most useful document that I found was the EUIPN common practice. At that stage, it was on the second consultation draft, and I read, I think it was yesterday or the day before, that has now become the final draft within the EUIPN, and it's now going forward in the expectation that it will be endorsed by, I think there's 2 committees that it must go through before it becomes a settled or established practice statement. And that may happen by about October of this year, I believe. Now, in that document, it differentiates, for the purposes of analysis, between 2 different facets of bad faith filing. I'll paraphrase them. The first one is where there is another trademark proprietor or a group of trademark proprietors or users who are the victims of what the trademark applicant has done. He targets an opponent, he targets someone that he's a competitor, and he does so in an unfair way. So you can call that the first branch. And the second branch is abuse of the trademark system. And then you have this phrase, which the Court of Justice has now said twice, once in a case called Coton and the other time in Sky, applying for registration for purposes other than those falling within the essential function of a trademark is what the EUIPO document says. Sorry, EUIPN document says. But I'll flag up now what the Court of Justice actually said is in the plural. What the Court of Justice said, applying for registration for purposes other than those falling within the functions of a trademark. And if you've spent not very much time, but enough time studying the case law of the Court of Justice, you will understand that the reference to the plural of functions is significant when it comes to the question of whether there's bad faith or not. So I ask two questions. Anyone who wants to can answer them. In paragraph 11, can an objection for bad faith filing operate as a substitute for other substantive grounds for refusal of registration? You can think about that. Does anyone want to shout an answer? No? I'll go. It shouldn't be possible, but there's a danger that it will in the way that the jurisprudence is evolving at the moment. The great problem with the concept of bad faith is it's very elastic, it's poorly defined, it's a moral judgment, and there is still scope for the moral judgment to be applied in a way which completely overrides the relative rights regime for the protection of individual rights. And I'll give you an example of that in a short while, I think. Second question in paragraph 11, does the requirement for bad faith, which I put in inverted commas, make this objection stricter and more specific than the doctrine of abuse of right, abus de droit, fraud of law? Every member state has its own law with variations on this. Is this stricter than the doctrine of abuse of right, which exists in the various different forms in the laws of the member states? Anyone want to answer that? No? I'll answer it. It should be. It should be. The problem here is, it's a familiar thing that you know from listening to arguments, the problem here is you can say that when there is bad faith filing, there is an abuse of right, there's an abuse of process. The danger that I see coming, and I literally mean a danger that I see coming from jurisprudential point of view, is that people want to reverse that proposition so that an abuse of right becomes bad faith. There are quite a few people who wish to synonymize the concept of abuse of right with bad faith. I myself think, for reasons I'll develop in a minute or two, that bad faith means bad faith, and it's stricter. Now, who can object? I think my fingers have got wet again, sorry. So it was working fine all the time. Perhaps I'm sweating too much. No, I'll carry on for a bit. Who can object? The answer is that anyone can object. You don't have to have a private right to object. Anyone can object. My fingers, I think, have got wet again. Okay, don't go far away. And in paragraph 13, you'll see that the court has gradually progressed in the way it deals with these things. Thank you. Paragraph 13, emphasis, there is no requirement whatsoever for the objector to be the proprietor of an identical or similar earlier mark or sign protected either by registration or as a result of use in the territory covered by the application for registration. And then that has become, if you like, stronger still in the citation I notice in paragraph 14, which is the assessments for the relative rights grounds, they say, are not necessarily applicable, keeping all the options open, not necessarily applicable to a finding of bad faith. And then the bad faith objection is fundamentally different. That's why I was emphasizing that bad faith means bad faith. It should be fundamentally different. It should not, in fact, be superseding or absorbing other substantive grounds of registration. Right, now, the case law enables me to say quite confidently at this point in time that bad faith filing is a freestanding ground of objection to registration. It isn't governed by, and nor is it exhausted by, the operation of the relative rights provisions. It took me a long time to realise that it was as broad as that, but I'm confident that that is the position. Now, in some systems, and I understand that it is the system here in Latvia, it is possible for the office to raise objections on absolute grounds during the application stage. Now, ex officio objection, bad faith, presumption of good faith, what is the office going to do? So I had a case in England, that is a reference to a decision of mine, in which the applicant had applied to register trademarks. They weren't real football emblems, but they were like football badges. In one of them, the word Henry, Thierry Henry, appeared, and in the other, Ronaldinho appeared. The UK IPO said, go away, you can't have those. It's bad faith for you to file these registration applications for these famous names. If you think you're entitled to do it, go and get their written consent. Now, which is fine, except it really doesn't work. Because what happens is, in order to mount that objection, the examiner in the UK IPO carried out internet searches, wrote challenging letters to the applicant. The applicant got very upset and angry about being accused of having acted in bad faith, and wasn't mollified by the answers, wasn't reassured by the answers that he got from the UK IPO saying, oh, no, it's just an objection to registration. I'm not really accusing you of being a very bad person. They were. And he got very upset about it. Now, they dismissed the applications for registration on bad faith ground. The appeal came before me, and in the end, I said it's got to be stopped, because, as you can see from the way I've written it, in paragraph 16, and that echoes what I wrote in my decision, the office, ex officio, would be acting as investigator, prosecutor, judge, jury, and executioner, all at the same time, when it's supposed to be acting under Article 6 ECHR principles as an independent and impartial tribunal. Not good for independent and impartial tribunals to attack people ex officio for acting in bad faith. More to the point as well, the objection that was taken by the UK IPO involved protecting what it understood to be the legal rights of Henry and Ronaldinho, and those rights, if they were going to be protected at all in the system, should have been protected in an opposition proceeding in which they or their companies or whoever invoked those rights. Now, by taking the objection, enforcing it, effectively enforcing the rights of Henry and Ronaldinho, the office put itself into a position where it was prejudging any possible opposition that might then subsequently come before it that these people might want to bring. In other words, in my view, the office compromised itself by behaving in the way it did ex officio. Now, I believe my decision's not entirely popular in various quarters, but there you go. These are the things we have to put up with. But they have revised their practice, and now their present approach in the UK is only to take bad faith objections ex officio when, I think I could say, it's blatantly obvious what's going on. And we know those cases, we see them, and you've probably had those cases, most countries have had those cases where the people do serial filings, constantly serial filings. They try to extort money out of the opposite party, and then just before it gets to the point where they have to pay some money themselves, they withdraw it, and then they refile another one. There's been quite a lot of that. Now, we get to, in paragraph 17, I'm talking about knowledge, intention, and motives. There's a little piece of law. It's not a little piece of law. There's some law which you get out of the Court of Justice on this question of what is and what isn't relevant in terms of knowledge. Thank you. I don't know what I'm doing wrong. Sorry, but thank you. Well, we know, if you look at paragraph 19, the intention of the trademark applicant is a subjective factor. We know that. How could it not be? But it must be determined objectively by the competent administrative or judicial authorities. It must be the subject of an overall assessment taking into account all the factual circumstances, etc., etc., etc. Okay, how do you conduct an objective assessment? You have hard facts, if you have hard facts, and some cases are quite straightforward in that respect, but certainly in the UK, I see plenty of appeals in which they have what the English lawyers call a swearing match. A swearing match is where one side puts in witness statements supported by statements of truth, not quite affidavits, but they have the same legal status in terms of evidence, and the other side puts in completely contradictory statements, also supported by statements of truth. And then the question is, what do you as the tribunal do? And I can tell you that no amount of being told that you must look objectively at all the factual circumstances will enable you sometimes to, in many cases, it will not enable you to write a judgment that says, I've read that, you're a liar, you're a bad faith applicant, it's been shown against you that you no longer have the benefit of the presumption of good faith, you're a bad person. And still less can I do that in England in circumstances where the superior courts have repeatedly said, if somebody says something in a solemn form under a witness statement, then unless you can contradict them, completely contradict them with some other hard evidence, they are to be believed on what they've said. Now, I've had quite a few discussions over the years with judges from other countries in Europe as to how they deal with this. So the Netherlands was interesting to me. In the Netherlands, to try and get to the truth, they'll have a statement come in on one side, and then the next one comes in on the other side. And the first thing they do is apparently look to see which points were not answered that were in the statement that came in first. Then they wait for the reply to the second one that came in to see, again, which points were not answered. And gradually, as they keep doing this, the whole thing comes narrower and narrower until they can firmly identify a point that wasn't answered in relation to which the other side has put forward something that feels solid and convincing. Now, I asked them how they do this. They have confidence in that system, and I think you can have confidence in that system. But if all you're doing is relying on assertion and counter-assertion, there are many bad faith filing cases in which there may be difficulties coming to a conclusion. Now, bear with me for 1 second. Right. Now, so what is the test? Oh, sorry. I want to go back to paragraph. Yeah, thank you. Go back to paragraph 20. How did that happen? What am I doing? Right. The General Court has repeatedly said that the concept of bad faith is not defined, delimited, or even described in any way. That, I'm afraid to say, is a statement of the problem. It's not a statement of the solution to the problem. You look to see how the jurisprudence has developed, and you find that the Court of Justice speaks in one way, and the General Court speaks in a very similar way, but not quite the same way. This does not help. So the Court of Justice, there must be objective, relevant, and consistent indicia tending to show that the application for a trademark was filed, the applicant had the intention either, so notice you have it either way, either of undermining in a manner inconsistent with honest practices the interests of third parties, so that's the attack on competitors or whoever, or a business associate or something of that kind, and then the other limb, or obtaining, without even targeting a specific third party, an exclusive right for purposes other than those falling within the functions of a trademark, plural. Now, that second limb is the subject of a lot of argument in the case law, a lot of discussion, because it's quite difficult actually to establish the first limb, but using the second limb, you can start to evolve concepts of what the actual effect of the application for registration is, looking at it from a systemic point of view. Paragraph 22, the General Court speaks of the need for subjective motivation, thank you, on the part of the trademark proprietor. I've lost it again, right? Namely, a dishonest intention or other sinister motive. I don't quite know what a sinister motive is, but it's intended to be broader than a dishonest intention, involving conduct which departs from accepted principles of ethical behaviour or honest commercial and business practices. Well, yes, that again is a description of what can be regarded as bad faith. You might think it's actually not serving properly to act as anything that you could run a slide rule over to measure the incidence of bad faith. Now, paragraph 23, I would draw special attention to. The case law in the General Court is quite clear. They say that the proprietor of the trademark at issue is best placed to provide the decision taker with information about intention at the relevant date. Absolutely true, absolutely true. Now, what this is doing, or has done, is it's created a situation in which people who are reading and then applying the General Court case law are saying, oh, what's the explanation for this? And they treat the case as one in which the defendant, the trademark applicant, is required to provide an explanation. So, in my view, the analysis should be different. In my view, the analysis should be, you may think it's purist to say this, it is the accuser, it is the objector who must overcome the rebuttable presumption of good faith. The accuser must present evidence which is sufficient to make a finding of bad faith possible. At that point, the tribunal can turn over and say to the other side, do you have an answer? Do you want to share it with me? What is it? Experience shows you that the answers will be all sorts of random things and won't be particularly convincing. But the key point I wish to make is that at no point in that exercise does the burden of proof reverse. All that happens is that the point is reached at which the accuser is able to say the accused should give, the other person should give an explanation, and if they don't, then my case should succeed. And there is a difference. You may call it a subtle difference, but there is a difference between that and applying a rebuttable presumption of bad faith. And if I may, I would just warn you that adopting a rebuttable presumption of bad faith is, in the end, not a very good idea from the legal point of view. Tribunals want to do it because they want to establish a rule, if they can, that an applicant who's done such and such a thing in such and such a circumstance has got to provide an explanation for doing it, because if they don't, they're in bad faith. That's just another way of inventing a filing rule or a behavioural rule without in fact judging the specifics of the individual case, just applying a pattern or procedure. Now, dishonesty, the Court of Justice has basically insisted, the Court of Justice has basically insisted, do you think I've got no electricity in my body? The Court of Justice has insisted on using the word dishonest. Bad faith presupposes the presence of a dishonest state of mind or intention, but regard must be had to the context, which is that of the course of trade. So to give you an example, this came up in the hearing in Sky versus Skykick. I may file an application for registration, and I don't know what the fee is, but let it be 400 euros or something, I don't know. If I steal the money, I've behaved very badly. But it's not relevant bad behavior. It's not what they are trying to drive at when they talk about in the context of the course of trade. So the fact that I stole the money when I tried to register Alexander von Muhlendauer's name as a trademark for legal services isn't the point. The point is that I stole his name. That's the dishonesty. That's the bad faith. Now, the General Court has twice rejected the suggestion, that bad faith, I'm really sorry, that bad faith is not required. Because it rejected arguments to the effect that it's simply an abuse of the system and that's sufficient. They've rejected that. I've emphasized that bad faith of the second kind, which is applying for registration for purposes other than those within the functions for which a trademark is protected, I emphasize the plural, and it's really, I think it's important anyway, the functions doctrine most recently comprehensively dealt with in the Mitsubishi case that I note in paragraph 33, repeats the proposition that the functions are not just the origin function, but guaranteeing the quality of the goods or services, the communication function, the investment function, or the advertising function. And if you were to go to some of the textbooks which have been published in Germany, possibly also in the Netherlands, you'll find that the authors, in some cases, have identified up to what they identify as 28 functions that a trademark might be capable of performing. My own view is that there is the one function that all trademarks are supposed to perform is the communication function. Everything else is to do with, is it a communication about origin? Is it a communication about quality? Is it a communication which secures the investment of the business concerned? Is it a communication for advertising or promotion? So for what it's worth, my view is that the key function of a trademark is communication. Now, the battleground, I've kept it short because I don't want to say anything that I might get shot for in England, having argued the case in the Supreme Court. The battleground is over the question of no intention to use. The system that we have in the EU and the English common lawyers with their long history back to 85, possibly also in Ireland, but anyway, the English common lawyers hated it. They hate the idea that you can simply apply for registration without having a present intention to use. Well, the system allows it. You're not required to have an intention to use, and you have a period of 5 years for beginning actual use. And that period of 5 years does not even begin to start until the registration procedure is completed, which, as you know, in a fair number of cases can be 2 or 3 years. And what's more, the case law, that case I've noted in paragraph 38, it took me really by surprise about the strength of it. The General Court in that case, Cleopatra Queen, made it clear, at least on my reading, that you cannot file a requirement for intent to use, proof of use, sorry. You cannot file a requirement for proof of use of a mark, nor can you start prospectively in advance of the 5-year period to make an attack for revocation on the ground of non-use. That tells you how much and how important, how much weight and how much importance is to be given to that 5-year period within the EU trademark system. I personally would put it very high. I would say that every applicant who files for registration is provided with a legal guarantee that if it's put onto the register at the initial stage, they will have a guaranteed 5-year period in which to begin use. Now, of course, the English lawyers weren't satisfied with that, and then you get to this bit which is the essence of the argument in the appeal to the Supreme Court. So they would accept now that there is, grudgingly, for some time now, they've had to accept that there is no requirement for an intention to use, but the argument has now moved. The argument's now said, aha, if you have broad coverage, you cover so many things, and anyone who's looked at any EU trademark registrations will know how very, very long some of them can be. If you cover so many things and you don't have a coextensive intention to use across that very great wide range of goods, then in those circumstances, you can be guilty of bad faith. And that, in essence, is what the appeal to the Supreme Court is revolving around at the moment. Now, I ask a question in 44. When you see an item listed in a list of goods and services for a trademark registration, and it's in general terms, take the one that we spend so much time arguing about, which is computer software, for example. is that wording, does it describe a category of goods or services, or does it define a catalogue of goods or services? Because if you take that reference to define a catalogue, the applicant is deemed or found by interpretation to be covering with his application for registration every conceivable possible form or manifestation of computer software. And then you can attack him. If, on the other hand, all it does is describe a type or kind of good or service, then you can't mount that attack. I believe, I would hope, I expect, but who knows, that they will address this in the Supreme Court, that the language you use is not, at this stage, at the application stage, is not to be treated as a claim to a catalogue of every conceivable kind of thing. I would hope that. If not, then you may find that the bad faith objection goes even further than it's already started to go. Now, how am I doing for time? Not very well. 5 minutes? 8 minutes? 10 minutes? Okay, I'll buy that. 10 minutes is good, thank you. Target ventures. This leads into the panel discussion, which is going to come next. So this is, if you like, my early contribution to that panel discussion. I didn't realize until I started looking at the Common Practice CP13 draft that a lot of weight had been placed by the EUIPN on this, not a lot of weight, but a significant weight had been placed on target ventures. And then I looked at target ventures and I thought, what's going on here? Now, I'll try and get across to you what I think was going on here and why I also think that it's kind of like wrong. So slowly I look at it. My paragraph 45, target partners GmbH. This was a venture capital fund established in Germany, and they had a trademark which was registered in the EU, which was Target Ventures. And they'd applied for it in various classes in 2015, 35 and 36. Before that, they had used the domain name targetventures.com since 2002, and the domain name targetventures.de since 2009 for websites. And here was the point that the General Court took strong exception to. They used those websites to set them up to redirect traffic to its official website, which was targetpartners.de, where everything on their website, their main website, discussed all their goods and all their services under their mark Target Partners. Pausing there. This, as you may well know from trademark work that you've done, is, if you like, standard search engine optimization practice to set up redirect sites, because it enables you to pull in traffic which you immediately redirect to your main site, and often you use misspellings of your own mark because of the capacity that people have to make a keystroke error. And you set up some people set up many of them, but so there were just two. But there, up until now, there's been nothing wrong in the idea that someone set up a redirect to channel inquiries, searches to their own site. Now then along comes the objection. So Target Ventures Group, by now you're as confused as I am, because it's one of those cases. You probably find them when you ever come to take decisions on trademark cases. The moment you find yourself, when you're writing them, just thinking, which one is that? Let me just check, have I written the right one down in my decision? You know you're looking at something which is too close, because even when you know there's an issue and you're still hesitating as to which one it is, you're telling yourself that something's not quite right. Anyway, there they were in the British Virgin Islands, and they claimed to have operated under the name and mark Target Ventures on the Russian market since 2012 and on the European market since 2013. And you'll notice that those dates are a decade after the redirect sites had been set up by the Target Partners organization. Now, the General Court upheld the objection to invalidity on the ground of bad faith filing. So here we go. Paragraph 49. This is where, I'll tell you now where this is going. This is where the court decided that even though the case was being set up for decision as a invasion of my rights case, so the first type of bad faith filing, even though the argument from the British Virgin Islands was these people are trampling over me and my trademark rights, the General Court decided, and the first symptom of it is in paragraph 27 of its judgment, that it was going to deal with it on the other basis, which was applying for a trademark for purposes other than the protection of the functions of the trademark. That's the second branch. So they get there slowly. They criticise the Board of Appeal. The Board of Appeal said 100% the truth. The Board of Appeal said, in stating in the contested decision that bad faith involves conduct, etc., you've seen that, the Board of Appeal interpreted the concept of bad faith too restrictively. At that point, the warning light is flashing to the reader. Why are they saying that when that's been said maybe 100 times? Right. Then, in paragraph 28, they say, in their judgment, it isn't necessary for a finding of bad faith for the applicant to have had knowledge of the third party's use of the sign at issue. Now, normally, knowledge is a major component of any well-grounded finding of dishonest behaviour. It's what you knew relative to what you did with that knowledge that gives rise to the finding. So they're dispensing, in paragraph 28, with the requirement for knowledge. More specifically, they went on, this is paragraph 51, the intention which gave rise to the filing of the application for registration of the contested mark was that of strengthening another mark, target partners, since the websites, and those are the redirect websites, did nothing other than provide a means of redirection to the applicant's main website. Well, so what? It's not a very judicial way to say it, but so what? They say that was not with the aim of engaging fairly in competition, but with the intention of obtaining, potentially without targeting a specific third party, an exclusive right for purposes other than those falling within the functions of a trademark. By this point, I have to say they've lost me because I just don't agree with this reasoning. And why do they say it? In 52, the fact that the applicant, that's the trademark applicant, registered a mark in order to prevent a likelihood of confusion with another mark, target partners, of which it was already the proprietor, and or in order to prevent the element that is common to those marks is extraneous to the functions of a trademark and contributed more towards strengthening and protecting the applicant's first mark, which was the only sign under which the applicant offered its services. Now, if you've been involved in infringement cases, for example, of the kind that led to the Interflora litigation and the cases which preceded it in the Court of Justice, if you have been involved in those cases, you will know that the sponsored link which comes up, or used to come up, it doesn't come up in quite the same way now, but the sponsored link or connection that used to come up when the searcher types in the search term, which is the brand in question, nobody has ever doubted that when that causes a link to come up, which is then clicked on, which then sends the person who's searching across to a website, nobody has ever doubted that that constitutes use of the search term in relation to the website and the content of it, the commercial website, where the searcher ends up, the landing page. Nobody has ever doubted that, except the General Court, who seems to say this was not a trademark, it wasn't trademark use, etc., etc. So with the greatest of respect, I cannot believe that this decision will withstand close scrutiny, and I would urge, even if it's not too late, I would urge the EUIPO, the EUIPN, to think about how they might just look again at what they've said about this decision, because I don't think that this decision is actually a true judgment on dishonesty. That's what I think. Thank you.